Like the United States, Iowa has a history of equality and discrimination. Advocates for various causes have sought to change the state constitution, and judges in Iowa courts have often interpreted the Iowa Constitution and state laws to uphold equality. Iowa's first territorial Supreme Court case recognized the rights of all people. Ralph, a man enslaved in Missouri, had been working in the lead mines around Dubuque to earn his freedom. When slave catchers attempted to return him to his enslaver, local residents supported Ralph's quest for freedom. Chief Justice Charles Mason wrote the opinion on July 4, 1839, that slavery did not exist in Iowa and that Ralph was to go free. At the same time, laws of the Iowa Territory discouraged black settlers and required a $500 bond for any blacks coming to the territory. At the beginning of Iowa statehood, the state did not provide education for black children. When communities later offered public education to black children, many communities, including Dubuque, Des Moines, Keokuk, and Muscatine, had segregated schools. After the Civil War, in 1867, Susan Clark of Muscatine sought to attend a nearby school. The school board of Muscatine attempted to force her to go to the poorly equipped school for black children. The Clark family fought against the discrimination, and both the district court and the Iowa Supreme Court ruled that Iowa law prohibited segregated schools. Justice Chester C. Cole wrote the opinion for the Iowa Supreme Court that was released on April 12, 1868, and more than 86 years before the federal case of Brown versus the Board of Education in Topeka, Kansas. Another important Iowa Supreme Court case was Coger versus Northwestern Union Packet in 1873. Emma Coger, a teacher from Quincy, Illinois, had both African and European ancestry. When she wished to dine in the main cabin on a steamboat on the Mississippi River near Keokuk in 1872, the ship's captain forcibly removed her because she was viewed as a black person, and the steamboat company segregated its dining spaces. She sued for discrimination and won her case, thus making it illegal to segregate many public spaces in Iowa. Iowa would pass civil rights bills in 1884 in an effort to make sure all Iowans were treated fairly. This law was not always enforced, and discrimination continued in many Iowa communities. The Iowa Civil Rights Act of 1965 provided a more formal process to guarantee equality. American Indians in Iowa have faced removal, forced education, and discrimination. The Meskwaki of Tama County are the state's only resident tribe. When the federal government tried to force the nation to Kansas, they worked within the Iowa government to purchase land in 1857 to establish their settlement. While Meskwaki men served in World War I in 1917 and 1918, they could not vote in elections. It wasn't until the Federal Snyder Act of 1924 that American Indians born in the U.S. received full U.S. citizenship. In the 1970s, American Indian advocates, including Maria Running Moccasins Pearson, fought to protect American Indian burials, leading to a change in Iowa law in 1976. A more recent ruling on equality by the Iowa Supreme Court was in the case of marriage equality in the case of Varnum versus Breen in 2009. Using the basis that no harm was caused by same-sex marriage, Justice Mark Cady wrote the unanimous opinion allowing for marriage equality in Iowa 6 years before Chief Justice John Roberts wrote for the majority of the U.S. Supreme Court, who ruled in a similar fashion. Iowans have rightly fought for equality and fair treatment. These stories of advocacy and judicial rulings are excellent examples for study and to serve as an inspiration.